Good morning, everybody. I'm Dan Diker, the director of the Institute for Contemporary Affairs, and I welcome you on behalf of our president, Ambassador Dr. Dori Gold, and our Director General, Chaya Hershkovitz, and many of our fellows and associates of the Jerusalem Center for Public Affairs. Clearly, the naval blockade issue, as well as the situation in Gaza, is an enormous issue, and it's not going away. It's actually going to be front and center in the on the international agenda for many weeks to come. Clearly, reports that there are more ships on the way creates an urgency to understand the whole legal diplomatic aspect of the naval blockade and the issues surrounding it. So we thought that there would be nobody better, certainly in the State of Israel, to address the legal perspective on the blockade than Professor Ruth Lapidoth. And Professor Lapidoth's tens of years of experience and reputation precede her in the international community, not only in Israel. She's widely considered one of the leading authorities on international law. She was the recipient of the 2006 Israel Prize in Legal Studies, and clearly has won many other awards. She was the 2000 Prominent Women International Law Award from the American Society of International Law. She was a legal advisor. Professor Lapidoth was a legal advisor to the Israeli Ministry of Foreign Affairs and has been a guest lecturer and researcher in many leading academic institutions around the world. And you're the author of 9 books, Professor Lapidoth, I believe, or 10 books on international law, and and well over 100 articles on those subjects, including human rights, the Arab-Israeli conflict, and Jerusalem. So I'm going to ask Professor Lapidoth if you would share some thoughts with us on the blockade, and if you have questions about Gaza in a related context, Professor Lapidoth would be happy to entertain those questions as well. Professor Lapidoth.
Thank you very much for that lovely introduction. It couldn't be nicer. I really appreciate it. I love compliments.
In that case, I can get up for another 10 minutes.
I'm sure that all of you have read a lot about the facts, what happened, what did not happen. You have seen the newspapers, you have seen the television, we have heard the radio. So I will not deal at all with the facts. What I am going to try to explain to you is the legal aspects of the problem of the blockade of Gaza. I try to make it as clear as possible, but if you feel that something is not clear, don't hesitate to ask, and I'll be happy to try to answer if I know the answer. First of all, the first thing that we have to mention is that the situation between Israel and the Hamas is a situation of armed conflict. Why is this important? Because this means that on the relations between Israel and Gaza apply the rules of the laws of war, which means, and we'll come back to this in a moment, that you may control ships going to Gaza even on the high seas. You may not do it in the territorial sea of a third country. We could not have done it in the territorial sea of Cyprus. But on the high seas, in time of armed conflict, you may check vessels and aircraft that are going to the other side. This was the introduction. Now, I prepared a definition of what is a blockade. I'm afraid it's a little bit too long because you will fall asleep. The main idea is a blockade means that one state prohibits the entry and the exit of both neutral and enemy ships and aircraft to an area which is considered by this party to be subject to this blockade. And you have to define very clearly what is this area. Where are the borders of this area? You see, the whole definition was 2 pages, too much for you. So now we know what is a blockade. Why did I think that we have to define a blockade? Because there are some similar institutions in public international law. You have what they call exclusion zones, you have security zones. All these are names that apply and describe institutions of the laws of war on the sea. But we are now limited here to our discussion of the blockade, because this is what Israel has imposed on the shore of Gaza. Now the first question that we have to deal with, well, it's the second. The first was a definition. The question is, what are the sources of the law on blockades? And this is very interesting, because until this very day, the rules on blockades are still customary international law. You will not find an international treaty which deals with this problem. So I'll give you a list of the documents which mention it, but remember it is customary law. So the first mention of blockades, well, the blockades have been in existence for hundreds of years, but it was mentioned specifically in the 1856 Declaration of Paris after the Crimean War. But this is a very short mentioning of this blockade. Second text, which is much more important, more detailed, is the 1909 London Declaration on Naval Warfare. Now this declaration really had the intention to codify the rules concerning the war on the sea. But unfortunately, the states that participated in this declaration did not ratify it, which means it has remained a declaration, but it is not a treaty because it has not been ratified. Nevertheless, the manuals of the laws of war of the most important countries, I would say the United States and England and Germany, and there is also another manual which was prepared by an international group of experts. They call it the San Remo Manual. When anybody speaks to you about the San Remo agreement, there is no agreement. It is a manual. So we have the manual of the United States, of Great Britain, of Germany, of San Remo. They all say that the laws of the blockade are still the laws of customary international law. And they define these rules very clearly. And I think now we come to this, another remark. On the laws of war on the sea, of course, apply also the general principles of the laws of war. I just give an example. In the London Declaration, there is no mention of the prohibition to starve a civilian population. But this is a general principle which has been adopted later by the Geneva Conventions and by the Geneva Additional Protocols, 49, 77, so that when we look at the rules that apply to blockades, we should also remember that the general principles of the laws of war apply also to the situation on the sea. Now, the very important question, of course, is what are the conditions for the legality of such a blockade? Now, the first one is that you have to declare and notify as much as possible if and when you apply a blockade. Of course, things have changed since 1909. Now we have much more sophisticated means of notification and of possibilities to let the other side and all people involved know about what's going on. So nowadays, the problem of notification is much easier than it used to be in the past, because communications are so much easier. I'm sure this is not mine, by the way, but most people have these little things and they can hear anything which is going on in the world. So we have the problem of notification, and it has to be notified as clearly as possible to all those who might be involved in a problem concerning the blockade. Second question is effectiveness. You cannot apply what they call a paper blockade. A paper blockade is not valid, it's not legal. It has to be effective, which means you have to apply and to enforce the blockade, otherwise it will not be valid. Here again, since the technological progress of the world is enormous also in these areas, it is now much easier to apply an effective blockade than it used to be in the past. In the past, you needed to have the ships just standing there. Now this is not necessary anymore because you have airplanes and you have possibilities from far away to see what's going on. The question of effectiveness is a question of fact, which means there are no clear legal rules which tell you what is effective and what is not effective. So in each case, you have to look and see what is happening on the ground. So we have had notification, second effectiveness, and now we come to the third one, which is if you apply a blockade on a certain shore, you must be sure that you do not cut off from the high seas the territorial sea of a foreign state. For instance, if we had here a situation where, I should close the as well, never mind. If we had had a situation where you cannot get to the territorial sea of Egypt, except if you go through the territorial waters of Gaza, then I would say, here you have to make an exception because you cannot get to that territorial sea without going through the area which is blockaded. But in our situation, it is not like that. You go to the Egyptian shore and territorial sea without any need to go through the area which has been blockaded by Israel. And now we come to number 4. It has to be based on equality. If you apply a blockade, it has to apply to everybody, and not only to some ships or some aircraft. Of course, there is always the possibility that the state which has imposed the blockade may give special permission to certain neutral ships to go through, but these are the exceptions. It has to be in principle applied to everybody, including prime ministers who might be on any of the ships. And now we come to the next condition. You must permit the passage of humanitarian assistance. And this is a very interesting provision because, and this I looked up of course very carefully, for instance in the San Remo Manual of 1994, they say you must allow the passage of humanitarian assistance, but on 2 conditions: that the state that applied the blockade can decide where and when and through which port the assistance will reach the coast. And in addition, there is also a possibility to require that a neutral organization or neutral person on the coastline should control to whom the assistance goes. They say, like for instance, the International Committee of the Red Cross can check where does the assistance go. Does it go to the civilians or does it go to the Hamas in this case? And if you are interested in this provision, I think this is Article 103 of the San Remo text. Another provision, another thing which I wanted to mention is, you may not starve the civilian population. This I mentioned already earlier. This is not written in the 1909 text, of course, but this is the result of general international law of war as it has now been accepted. So these, I think, are the conditions for the validity of a blockade. Now we come to the next question. The question is, what can and may be done to a ship that is trying to disobey this blockade? And here we have to make a distinction between merchant ships and warships. With regard to merchant ships, the principle is that you have the right to what they call capture. The word is used. The word they use is capture, visit, search, and if the ship resists, you may even attack it. This is the principle with regard to merchant ships. When it comes to military ships, to warships, the situation is a little bit different. You may also here try to capture, try to search, but you may not attack a warship unless it is a situation of self-defense. This is based on all the 3 or 4 manuals that I mentioned earlier. Now the next question would be, where can you start to apply this blockade? Where can you start, in what kind of waters can you start to control? And the answer is, as soon as it is clear that a certain ship intends to break the blockade, you can start to deal with it, even when it is on the high seas. Very difficult. I'm sure it is a little bit technical, but what can I do? Now, of course, you will be interested in precedents. Precedent number 1 that I would like to mention is, I mention only the modern cases, because the old ones you know, and they're perhaps not so relevant. Of course, during the 2 world wars, there was a lot of blockade, and even starvation. And I remember there was a discussion in the House of Lords in England, and the army said, we have the right to starve the population, the German population. Nowadays, this is not anymore permitted. So after the Second World War, I would mention a few precedents. Precedent number 1, during the war in Korea, between North and South, etc., between 1950 and 1953, there was a blockade. Second example, Bangladesh. When Bangladesh tried to free itself from Pakistan, India applied a blockade. That was 1971. Another example, in the war between Iran and Iraq, which took place from 1980 till 1988, there was a blockade of the Shat el-Arab. Shat el-Arab is the place where the 2 rivers meet, and where it is very large, and which is very important for the export of food and oil, of course. Interestingly, there was also blockade in the 2006 war between Israel and the terrorists in Lebanon. There was a blockade, and nevertheless Israel gave them a safe passage from Lebanon to Cyprus in order to get humanitarian assistance. I think I've given you enough examples. I don't know any more. I have another one. I think this is more or less... Yeah, there was a dispute when the war between Russia and Georgia took place in 2008, whether there was a blockade, but according to some of the articles that I read, this was not a real blockade. It was more a question of catching contraband on the high seas. Contraband is goods that can help the enemy. So it was not a real blockade. It was only a search of the ships on the high seas. Let's see, these are the examples that I wanted to give you. And as I mentioned already earlier, when we speak of blockade, we must distinguish between blockade and what they call exclusion zones and war zones. On the other hand, you have neutral zones. All these are certain zones, and each has its own rules. But we have dealt here in our short discussion only with the blockade, because the blockade is what was imposed by Israel on the shore, on the coast of Gaza. I thank you very much. I hope I've mixed you up completely.
There's plenty of time for questions and discussion about the naval blockade and the perhaps larger context of Gaza and Israel from a legal perspective. But Dr. Gold, you have a question?
Yeah, I think that I would just like your comment. States are reluctant to use the term blockade, even though in effect they use blockades in various conflicts. I'm thinking of the United States in 1962 during the Cuban Missile Crisis. Maybe they called it a quarantine, because if they had said it was a blockade would be an act of war, I believe. So they chose some kind of softer language of quarantine. Another case I ran into during my UN work was when, after Saddam Hussein's invasion of Kuwait in 1990, the United Nations Security Council adopted a resolution, it was 665, which prohibited armaments from going to Saddam's Iraq and established in effect, a blockade of Allied ships to prevent ships from going to Iraq. Now that, again, they didn't use the word blockade, but in effect it looked like the same thing. And by the way, that naval presence from 1990 in the Indian Ocean and the Arabian Sea is still there today, but it's no longer used to stop ships heading for Iraq, but rather to either seek out members of Al-Qaeda that are fleeing Pakistan and heading for Yemen or Somalia, or to intercept ships carrying weapons of mass, or allegedly carrying weapons of mass destruction.
Thank you very much, Dr. Gold, for these interesting and important additions. I have the impression, or maybe suspicion, that in those cases the term blockade was not used because not all the conditions were fulfilled. So in order to have a legal blockade, you have to fulfill certain conditions. Much easier, for instance, in the case of Cuba in 1962, they called it a quarantine. Why? Because they did not fulfill all the conditions of the blockade. So probably this is the reason, but I'm not sure. This is just a suspicion.
Interesting value of KCPA. I would like to ask you whether a blockade must be announced, or practicing blockade without announcement is legal as well.
Now, first of all, as I said earlier, it has to be announced, and it has to be announced loudly and clearly to everybody who is involved. Even more, when a ship is trying to get through the blockade, you must make sure that this specific ship knew that there was a blockade. So not only you have to notify, you have to notify it very clearly to everybody who is involved, but the specific ship who comes, you must check whether they had actual knowledge or presumptive knowledge of this blockade.
Just wanted to clarify context, a point of context. In your view, Israel is fully within its international rights to maintain this naval blockade and has fulfilled the conditions that would allow this, according to what we understand. It's almost a privilege to call it a blockade because you have to fulfill conditions as opposed to impose without fulfilling conditions. In other examples, as Dr. Gold pointed out, as a quarantine. But is Israel within its rights and in full compliance with international law as you understand it?
Absolutely. I thought that this was clear even without mentioning it, because all these conditions that I mentioned have been fulfilled by Israel. I don't have the exact date. I think the last date that I have in mind is January 2009. Israel made the notification to the whole world. So I think that in our situation we have fulfilled the various conditions, and therefore we could say this is a real blockade. Thank you for
Mr. Ambassador,
question.
thank you. Your Excellency, Mr. Ambassador, Ambassador from Mexico.
Thank you. I want to go back to your original premise with which you started your talk. You said that the legality of imposing the blockade rests on the fact that there's a state of war between Israel and Hamas. But wouldn't that entail also, from the legal point of view, a formal declaration of war? And what will be the legal justification in this case? I'm not very clear as to that aspect.
Now, in the past, declarations of war did take place. Nowadays, you have wars that break out without any declaration. And I think in this situation, nobody can say that he did not know that there was a armed conflict between Israel and Hamas. But your question is absolute to the point. There's no need for a declaration in order that there should be a state of war. There was a judgment by President Barak a few years ago. It's not a few, maybe 5 years ago, where he explained that the situation is so bad that it is really a situation of armed conflict and not simply of an internal conflict.
He was president of the Supreme Court.
He was the president of the Supreme Court of Israel. He had a very big reputation. He still has the reputation. Aaron Barak, I mean. Not the man who is now the Minister of Defense, but the man who was the Supreme Court president for many, many years.
Or President of the United States, if we're just talking about Baracks. Yes, hi.
Hi,
How are
Tova
you?
from the
Hi,
Jerusalem
Tova.
Post. Just for the sake of debate, I mean, you make it sound very clear, but if it's so clear, can you explain why other international experts think it's not? I mean, what's the opposite argument? What is the argument that says this wasn't a blockade?
Well, I tell you, this question is very interesting. I tell you why. Because each time, I just mentioned it to Dr. Dorigold earlier, those who say it is illegal don't say why. They just say it is illegal under international law, full stop. But they don't say why. So I cannot answer your question because I don't hear clearly why, according to that opinion, international law
But even without them saying it, do you yourself know where they might see a loophole? I mean, what is the loophole in the argument? Or is it so airtight that there isn't one?
I have not seen anything written on that question. I only hear all the time against international law, full stop. But I try to find out.
The Turkish foreign minister has contended that because it was in international waters, 100 kilometers or so from Israel, that it was illegal. He said that, the Turkish foreign minister.
Thank you very much. But as I said earlier, in time of armed conflict, you can search ships even on the high seas. So maybe his legal advisor did not give him the right advice.
Wait, can I start?
There are a lot of articles written on the international legal aspects that are not written by international lawyers. And I would just call them opinion pieces that have a shroud of law around them, but they're really not. One of the arguments is exactly that. And there were Israelis who were writing in Israeli newspapers that seizing a ship in international waters is a violation of international law, and had Israel seized the flotilla ships within Gaza's territorial waters, that would have been more proper. And as you said, there's no basis for that determination. Another thing I've seen many times among, again, opinion writers is that the laws of war don't apply to Gaza because Gaza isn't a state. And they say, well, they don't know what to describe it, but I think isn't that sort of like the cutting edge of international law today about how the rules of law apply to non-state actors who, for all intents and purposes, have the attributes of a state, but maybe haven't formally declared themselves, don't have UN membership, but in our judgment, the laws of war should apply. I think also in the issue of when the International Court of Justice in The Hague dealt with the legality of our security defense and wanted to deal with whether the right of self-defense applies to the case of the threats we were facing from the West Bank, there were those who said, well, that applies only in international conflict, not in the conflict you're facing with Hamas suicide bombers crossing into Israel proper.
But first of all, thank you very much. Those opinions that you mentioned probably were written by people who have not been my students. So they don't know their international law. I wouldn't let them pass the exam. With regard to the question, can Gaza be considered an enemy although it is not a state? This is a very big question. But you know, in international law we have, it's a little bit technical, I'm sorry. You have what they call international conflicts, and they have been defined in the 1977 Protocol Article 1. And according to this, the laws of international wars could also apply to a situation where an area is not an independent state. Secondly, we have what they call in the laws of war that apply to internal conflicts, which is very similar to international law that applies to wars between states. This is common Article 3 to all the Geneva Conventions, which gives the minimum which applies. In addition, I would mention that I read in one of the articles that I saw that the same rules could apply even within the same state if a group of terrorists gets hold of a coast or a port. But he did not mention what is the basis of his statement. He did not give me the article in the manuals. So this is why I did not mention it, but this is the general opinion. With regard to the status of Gaza, I think this would be the 64 million question. Gaza has been under Ottoman sovereignty from 1517, you know much better though, 1517 until 1917. Then it was part of the British mandate for Palestine. Now, who was the sovereign in the British mandate for Palestine? There are at least 5 opinions on that question. The most common one says that the sovereignty belonged to Britain plus the League of Nations. In 1948, England left. Britain left the area. So who is the sovereign? It was occupied in 1948 by Egypt, but Egypt never annexed Gaza. Egypt ruled Gaza like an occupied territory and later gave them some kind of autonomy, but under occupation. In 1967 it was occupied by Israel. It was already also in 56, but Israel gave it back. 1967 occupied by Israel. Israel has not annexed Gaza. So what is now the situation of Gaza? As I said, 64 million question. With $64 million question. It is, some people say it is and this is very easy for the lawyers to say, it is an area sui generis, which means a special situation. Others say it is a self-governing territory with certain powers and not with all the powers of a state. But sui generis is the best what we can say because really nobody knows exactly what it is.
Tarek, did you have a question?
I just wanted to ask if the principles...
You have a microphone just for the transcript to announce.
I wanted to ask if the principles of blockade would be applied in an armed conflict and in the case of occupation, and if there's a difference between both of them from an international legal perspective. My second question was, according to Resolution 1860 of the Security Council, Gaza is part of the Palestinian territories, and that's why it is occupied, and not because of effective control. In order to call it sui generis, it's an evolution of the effective controls here. Is my question here?
Well, with regard to the first question, I did not give you the whole definition, but the definition says whether the area is part of the other side, or it is under its occupation, or it is under its control, so that the blockade can apply also to this situation. That Gaza is part of the Palestinian territory, but so far there does not yet exist a Palestinian state. We hope there will be one in a few years, but for the time being there is no Palestinian state, so we cannot say that it is a state, Gaza. It is a special area which someday hopefully will be part of the Palestinian state.
So to make clear that just wanted to Tarek to make clear that part of the diplomatic governance of the relationship between Israel and the Palestinian Authority and the final solution of the territories is to be decided through by agreement and negotiations with the parties. So the notion of assigning a legal status or statehood status, or that it would be particularly Palestinian territory, is actually what negotiations since 1993 have been about. So there has been no, as I understand, perhaps Professor Lapidoth would correct me, but it hasn't been assigned to any particular sovereignty at this point.
That's right. You see, in both in the Declaration of Principles of 1993 and in the interim agreement of 1995, it was agreed that after a certain period of time there would be negotiations on the permanent status of the Gaza and the West Bank. And these negotiations so far have failed. I would also mention that the roadmap of the year 2003 says specifically there should be established a Palestinian state by agreement with Israel. So that I agree with you that it should be made by agreement. There's no question about that. Let's hope for the best.
David, can I just ask Jean-Claude, can you come back to Jean-Claude, would you have a question? Just announce your name and affiliation.
Jean-Michel, Eric de Presse.
Jean-Michel, excuse me, Jean-Michel.
Could you elaborate, Professor, you made a difference between merchant ship and military ship, and you said that only the military ship can attack in self-defense. What do you define self-defense, and when do you start to stop a military ship which is willing eventually to reach the Gaza?
Well, with regard to warships, the same principle applies like to merchant ships, which means when you see that the ship intends to go to the Gaza shore, to the Gaza coast, you can start to stop it, and you try to look what's going on there, and you try to persuade it not to go to Gaza. But what I said is that you, with regard to merchant ships, if the merchant ship nevertheless continues its course to Gaza, then you can attack it. But with regard to warships, this is not done. So the question is, what can you do if they do not obey? This is very, very, I say, it's not a good provision here, because they only say you can only protest if it is a warship. You can attack it only if you have a problem of self-defense, which means if that ship attacks you.
I wonder if I could take the opportunity to just ask a question to create a little bit more context. The whole issue of the naval blockade is connected to this notion of sending humanitarian goods to the Gaza Strip, which in many international centers is called under siege. The word under siege is used inaccurately or accurately according to claims. The question is, what is Israel's responsibility to this sui generis body called the Gaza Strip, which has two entrances and exits, one through Rafah, one to the Republic of Egypt, and one through to the State of Israel? And in that context, what is the accuracy or inaccuracy of that nomenclature, the word siege, imposed by Israel, as is claimed in frequently? And two, what are actually Israel's responsibilities and rights with regard to the passage of aid and other goods into the Gaza Strip?
Thank you. Well, first of all, with regard, you are absolutely right, and we have to stress it, that from the Gaza you can go either to Israel or to Egypt. And there is also an agreement of the year 2005 concerning the passage from Egypt into Gaza through the Rafah entrance, and there were specifications how this border should be improved in order that it should be easier to check the people and the goods that are going through. So it was the idea that both Rafah and the Israeli border should be open for the Palestinians. What are our responsibilities? They were mentioned in a very interesting judgment, I think, by the present Supreme Court President, Mrs. Benish. There was a case where the question was whether Israel had to supply electricity to Gaza. The opinion was that since the occupation of Gaza has ended already in the year 2005, Israel does not have a responsibility to supply Gaza with anything, in particular since there is an additional passage to Egypt through Rafah. But nevertheless, the Supreme Court said that since Israel had been in control of Gaza for so many years, it has a moral obligation to help the people in Gaza to get what they needed for their daily life. So this is more or less the situation.
Okay, one follow-up, and then the gentleman in the is that the Robert Goot from? Yes, right afterwards, Attorney Goot. You can ask. Pinchas, you want to ask a follow-up question? Okay.
No, it's already 4 months from now. So the EU stopped financing the diesel supply for the electricity for Gaza. Does it mean that also the EU is participating in the siege on Gaza?
First of all, I would not call it a siege, because there is no siege, because they get a lot of goods from Israel, and everybody knows it. And some people who have been in Gaza say there's no shortage of important elements. There was a shortage of cement. Why? Because Israel said, we don't want to send cement into Gaza because it is used by the Hamas in order to build new bunkers. But now they agreed that the cement from the ships that came from Turkey will also go into Gaza, but via the port of Ashdod, and there should be some kind of control by an independent group in Gaza to make sure that the cement reaches the civilian population and not the Hamas. So there is no siege, first of all, and secondly, I think that what Israel is doing now is really the market. Let me remind you that during the war of 2008, even during the war, every afternoon for 1.5 hours, the border was open, no military activity, in order to make it possible for humanitarian assistance to reach Gaza. So we should not forget the good things that Israel has done.
I asked about the EU.
The EU, sorry.
Yes.
The EU, well, I don't know what is their policy. Why they wanted to stop. Maybe they don't have...
For 4 months they don't finance anymore the diesel needed for the in Gaza. Does it mean that Europe is also participating in the blockade from Gaza?
They finance, but they never delivered it. They always financed the interest of it.
They financed it, yes, but
they stopped.
Delivering is
4 months.
I have no idea what is the reason. I didn't know that they stopped. I know that Europe has some financial problems. Maybe it is related to that question. But I don't know. The answer is I don't know.
I'd call on Robert Goot in the back for Australia.
Professor, thank you very much for a most succinct, straightforward, and very clear analysis. Sometimes things appear watertight because they are, as I think this issue is on the blockade. But I was interested in one aspect of the conditions, namely that it can't be a paper blockade, it must be enforced. Now, if Israel had allowed, without interdicting in any way, any of those ships in the flotilla to reach Gaza, would that have rendered ineffectual the blockade in the future? Or, if Israel had interdicted and then allowed the ships to pass to Gaza, would that have rendered ineffectual the blockade in the future?
Well, as I mentioned earlier, the state that applies the blockade can make exceptions, but it should not be that the exceptions are the rule. So that if Israel had allowed all the ships to go through, I would say that this would have been the end of the blockade, because it would not have been effective anymore. But if they had said only these ships, after proper control and inquiry, are allowed to go through, then you could perhaps say this was a special case where they gave the permission to go through, and they declare that after that the blockade will again be effective. By the way, there's another exception that I forgot to mention to you. if a ship is in distress because of the sea, then you can allow it to go into the waters which are blockaded, and this does not detract from the effectivity of the blockade. But as I said, the state may allow certain ships to go through, but it should not be the rule. It should not be permanent.
Victoria Guseva from the Russian Embassy. I would like to ask you about the right to control the ships that are passing through the high seas. Is this right goes to the ships that belong to the state which is in the state of war with Israel, or to all the ships? Because those 6 ships in Marmara, especially, it was the Turkish ship, and Turkey is not in the state of war, and that's why the rule to control the ship in the high seas, the ship that belongs to the state that is not in the state of war with Israel, should be applicable to this ship. For instance, one day the Russian ship would be in the Mediterranean Sea passing on the high seas, and that means that under the rule of the blockade, Israel could control it as well?
Well, the blockade applies only to the coast of Gaza, as I said. I think that the Israelis may control any ship where you have the suspicion that it might go through to Gaza. Not every ship, of course, on the high seas, but only ships that are suspicious.
And what are the grounds for this suspicion? Simply suspicion.
Suspicion that they carry goods to Gaza which may increase the war capacity of the Hamas.
Are there some basic criteria for this suspicion?
Well, the main, as far as I know,
like
the main criteria.
Declaration, like the criteria you've mentioned for the blockade.
Well, as I said, if there is the suspicion that they are carrying arms or personnel in order to help the Hamas, then of course this is a case where the Israeli army may intervene. With regard to other materials, I don't think that they would justify an act against a neutral ship.
Just to draw to your attention, what has been published in the last 48 hours is the fact that there were two terrorist operatives on the Marmara that were actually released by Israel. One was the key fundraiser for the Hamas. Another was the Iranian authorized Syrian interlocutor, both of which were considered by international agencies as part of a terrorist network, and they were captured, brought to Ashdod, and then released by Israel. So that the suspicions in this case were well-founded. Tarek, you have a follow-up?
I just wanted to return to the situation of Gaza. I needed to understand your legal opinion, and I'm trying to cope with all the technicalities. You're saying you're an outstanding expert. I'm not.
No, I'm not an expert, I'm sorry.
Much more than this even, if there's something that people describe you with. But my understanding is that the sui generis territory is a territory with a unique status.
Yes.
I see sometimes, like I mentioned, Resolution 1860 of the Security Council, which was issued in January 2009, describing Gaza as occupied and not sui generis, which is, I think, contradictory terms. They are not the same. If it's occupied, it's not sui generis. And specifying the reason of occupation is that it is part of the occupied Palestinian territories. This was one provision for one line in the resolution. So can we say that it's sui generis, and how is this resolution you see binding to Israel in this context?
First of all, 1860 is not a binding resolution. It is a recommendation of the Security Council. But you mentioned the question whether Gaza is occupied or not. And here the opinions again are divided. You have those who say, like me for instance, no, I give you my opinion at the end. Some people say that since Israel is still in control of the airspace and of the sea space of Gaza, therefore Israel is still the occupier. The other opinion says, according to the Hague Regulations of 1907, an occupier is only an occupier if he controls the whole territory. And of course, Israel does not control the whole territory of Gaza. If, for instance, in Gaza, a Hamas person kills Fatah people, we are not responsible. We are not in charge of Gaza anymore. So that you have these two opinions. On the one hand, those who say it is still occupied because Israel still controls the air and the sea, and the others who say it is not because Israel is not a full occupier of the whole area. Now, my opinion is that since Israel is not in control of Gaza, we are not the occupiers, but in those areas in which Israel still has control, which means water and air, the sea and air, in those areas Israel is responsible, which means if there is an accident in the air, Israel is responsible because she is responsible for what's going on in the air. So I think that here we have to distinguish between full control of the territory and on the other hand control only of the spread of the air.
Just as follow-up, we were talking that the blockade was based on the principle of international customary law.
Yes.
And in comparison of how binding this is, comparing to Resolution 1860, for example, which was issued under Chapter 6 of the Charter.
Chapter 6, not Chapter 7.
I understood,
Yeah.
but customary law is not always binding.
Sorry?
Customary law is not binding.
Customary law is very binding, my dear friend. According to Article 38 of the Statute of the International Court of Justice, the sources of international law are A, international custom, and I'll tell you in a moment what is international custom, B, international treaties, and 3, general principles of law that are common to most nations. Now, what is customary law? Customary law means when the behavior of states has been consequent in a certain way, and the states have behaved in that way because they felt an obligation to behave like that, this is binding customary law. And customary law is binding because it fulfills these two conditions. You can even say, but this is a little bit of philosophy, treaties are binding because according to customary international law, treaties are binding. Customary law was the basis of international law. Nowadays, there are many treaties, and you can say that most of international law is based on treaties, but there are still very important areas in which custom is the rule. And as I mentioned to you earlier, I mentioned 4 military manuals who all say this is binding customary law. You should come to my class on international law.
Also, resolutions, Chapter 6 resolutions are not binding or not self-enforcing resolutions. Is that correct? Just because they're being used by many for political purposes to use the word legal and illegal, but in fact, Chapter 6 resolutions are not self-enforcing.
No, they're not self-enforcing. They are not binding. They are recommendations. You see, the United Nations has 2 kinds of resolutions. One kind which are recommendations, and most of them are recommendations, and some are binding resolutions. Now the binding resolutions, there was an interesting judgment of the International Court of Justice concerning Namibia, where they said that in very rare cases, even a Chapter 6 resolution can be binding, but only if the history of the negotiations for this resolution show that this was the intention of the parties. Usually, Chapter 6 resolutions are recommendations, like the resolution of the General Assembly, and Chapter 7 are sometimes binding, not always. Even under Chapter 7, you may have recommendations, and it all depends on the language used by the Security Council.
Is there somebody that hasn't asked yet before I come to a second round with Jean-Michel? You asked one, sir, and I'll come back for a second round. Yeah, just your name, yeah.
Just one more remark. With regard to custom, I wanted to tell
Okay,
you...
I didn't see them in the back.
Just 1 minute. Half a minute.
Please.
To continue with regard to why customary law is binding, you have custom and you have usage. Usage is not binding. Custom is binding. So...
Pardon me in the back if I haven't seen you. There's some tall folks and I can't see, so please. Yeah.
Stephen, I'm an intern here at the center, and I've been researching this topic.
And just really quickly, I wanted to read for Victoria from the San Remo Manual, articles.
No. We would want to ask questions. The idea is just to ask questions of Professor Lapidoth, not to declare international law.
Okay, so my question is on Articles 2 and 3 of the 49 Geneva Convention. In terms of whether it applies to Gaza, as has been discussed here, I guess Article 3 reads, in the case of an armed conflict not of an international character occurring in the territory of one of the high contracting parties. So the argument to apply it to Gaza would be that Gaza is considered the territory of Israel?
No, because I said that it is according to the judgment of Justice Aaron Barak, it is an international conflict and not an internal conflict. Because Gaza is not part of Israel. Gaza has never been annexed by Israel, neither has the West Bank been annexed.
But if it's an international conflict, then neither Hamas nor any party in Gaza is a signatory to the Geneva Conventions.
Yes, but they're supposed to be customary law, except for very specific provisions.
David Essen. I want to ask about the response. If the Israeli blockade is legal, I'd like to ask about the responsibility for attempts to break the blockade under international law. For example, the Turkish government has denied that it sponsored the flotilla, but the Iranian government now is maybe even sending Iranian officials on the ships that it's sending. Is this a violation of international law? And if it is, would it also constitute casus belli?
Well, I would say that it is a cause for international responsibility. I doubt whether it can be a casus belli, because a casus belli exists only if there is an armed attack. And here there was no armed attack. So I would say it is international responsibility, but I wouldn't say it is a casus belli. Unless they attack, of course.
Sir.
Yes, thank you. Ingo Niemann from the German Embassy. I wondered, or I would just request a little clarification. If I understood you right, you say there's an international armed conflict between Hamas and Israel.
Yes.
Does this imply that all rules of the laws of war, including on the protection of civilians and the prisoners of war, are applicable? Does that maybe even imply that Hamas people who are captured have to be treated as prisoners of war, and maybe even the people on the ships who resisted the IDF action again? Thanks.
I tell you, this question of prisoners of war is a very complicated one. Israel is not a party to the 1977 additional protocol, which has this very, very large definition of what is a prisoner of war. According to the third 1949 convention, there are specific conditions that the group has to fulfill in order to qualify as prisoners of war. In particular, they have to act in accordance with the rules of the laws of war, and the Hamas does not do it, so the Hamas does not have the right to status of prisoners of war.
Have we satisfied the appetite of everybody? More questions?
Now I have the right for a cup of water.
Again. Okay. Last one. Jean-Michel. No? Okay. Last question, and then we'll sum up.
If the search of a merchant ship, after it has been captured, visited, searched, or eventually try to be captured, searched, but the boat continues, at what point is it allowed to sink a boat if it's full with civilian or civilian goods?
I think you should try to attack it and to get in charge of the ship. You do not so easily drown a ship, because the idea is to get control of the ship and not to drown it.
Okay. Ladies and gentlemen, would you join me in thanking Professor Ruth Lapidoth for a wonderful session? Yes, on July